Good day, everyone. My name is Jakob Öberg. I am Professor of European Union Law at University of Southern Denmark. And I'm going to speak today to you a little bit about my book, which is called Normative Foundations for EU Criminal Justice, which was recently published with Hard Publishing on 13th of June this year, open access. And I would like to extend my huge gratitude for Giuseppe Martinico and Enrico Cooperati for making this possible to record this little vlog. So what is this book about? Well, this book is about why should we have EU criminal justice? And, to actually discuss that, you have to think about why is this important? Well, it is important, in my opinion, because recently political charge event like the rule of law crisis in the EU showcase that criminal law is one of the most delicate policy areas of the Union. And it's also because criminal reflects the source of legitimacy in a given kind of political community. And this book seeks to develop like a theoretical framework in which to study when the EU could intervene by means of criminal law. And it does so by both combining criminal law philosophical theories, by looking at separate like frameworks like in economics, market failure theories, comparative federalism, transnational interest theories, brings from different kind of like theories and theoretical frameworks from different disciplines. And only by doing this kind of combined framework, where you look at both kind of criminal theory and sort of like more EU constitutional theories, you get a good sort of like backbone in how to study EU criminal law. And in the book, I first developed this kind of this theoretical framework, and then I looked quite comprehensively on several areas of criminal law. For example, domestic criminal procedure, substantive criminal law in Article 83, the European Public Prosecutor's Office and Eurojust, and also Europol. So it's quite like an extensive examination of various sort of frameworks. And the book's main argument is that the EU can only intervene in criminal law to protect transnational interests and European public goods, which is kind of like the key justification for EU action in this pillar. And it builds this framework on the basis of those theories of market failure, comparative federalism, and transnational interest theories. And it's also, the book also looks at so democratic theories, representation, political theories as justification for EU criminal law. And it's kind of like, builds back on the theory of why should we have sort of the European Union from the start? Well, we need the European Union to regulate collective action problems and deal with collective action problems ranging from several member states. So very much this take on criminal law is the same take as you would have as looking at when the European Union will regulate. So we're looking at basically transnational interest and things which are dealing with transnational implications. So that's also why I also think that there are different kind of theoretical framework which should be used for defending substantive criminal law and the rise and bigger mandates for criminal justice agency than domestic criminal procedure, for example. There are good arguments to criminalize in both of these or to use criminal law in both these areas, but there's kind of like this different justification because criminal procedure is a different matter than criminal law. So I think this is what I've been concluding also in the book. What I found when I looked at this, what I conclude with the book is that there is sort of an instrumental way of looking at criminal law and also autonomous way of looking at criminal law. So in my opinion, also what I argue for in the book is that instrumental justification is what's been used in the past. And that entails that you use criminal law in order for achieving another policy objective. It could be mutual recognition, it could be the enforcement of environmental policies, etc., etc. Whilst autonomous justifications are a broader way of looking at criminal law, where you use criminal law to protect common values, to have a political identity, and to develop a common sense of justice. And it also gives a broader remit for the EU to regulate criminal law. And whilst I think the autonomous justification model have a strong political appeal, it does kind of, the argument in the book does not fully endorse it, because I think the EU will gain its legitimacy if it adopts criminal law on this basis, because there is no clear legal base in the treaties to use autonomous criminal law. And it also suggests something about what the EU is as an organization, nature, this argument. Because if you're going to use autonomous justifications for criminal law, if it's especially substantive criminal law, while also using that to develop, a European FBI or a European centralized prosecutor, you need to understand the EU as a federal polity. And I think it is not today a federal polity, and it's not a federation as the United States. And that also means that we cannot have the same sort of autonomous justification using them when using the criminal law, but it needs to be more like this limited instrumental way of looking at criminal law for the EU to kind of like at the stage of how the EU has matured as a political community. And I think this is also the fact that, if the EU would have more autonomous political powers, and they also would have its own police agency, its own prosecutor, it also needs to have a much stronger sort of guarantees and fundamental rights for individuals and more accountability with those agencies. And I think today the EU has not reached that stage. So I finalized the argument in the book saying that since the EU has not reached this level of maturity, there is some more, the autonomous model cannot be fully endorsed in the book as a justification. Thank you very much for this opportunity to talk.